Welcome to the Retzel Health Law Hotspot. Health Law Hotspot is a podcast for physicians and health professionals that covers the legal issues and trends that affect the healthcare industry.
Hi, everyone. Welcome to the Health Law Hotspot. I'm Ericka Adler, shareholder and leader of the healthcare practice at Retzel and Andrus. Today, I want to do an updated podcast on terminating your employment agreement. For physicians and dentists, this is a topic that can be very sensitive, and it's important that you handle it in the appropriate manner. First, please make sure you review your contract. One of the biggest mistakes that doctors make is not knowing what their contracts say. Are you able to leave your contract, or are you locked in for some period of time? If you do leave, how much notice do you need to give? Does that notice need to be in writing? Does it need to be delivered in a particular way? This is one of the first things you should be looking for in your contract when you first start thinking about giving notice of termination. Second, if you're going to give notice because you think your employer is actually breaching the contract, make sure that you have evidence of a specific breach. Just because you think the employer's done something wrong, that may or may not be the case. Have they breached something that is specifically required in the agreement? Sometimes you're required to give them notice and an opportunity to cure whatever that breach may be. Have you done so? Have you given them that notice and a chance to fix? If not, then you cannot simply terminate because you think they breached. Make sure you're checking and giving appropriate notice if that is the case. And again, notice needs to be delivered as required by your contract. Typically, that's going to be hand delivery via certified overnight mail, something like that. So simply shooting them an email or leaving them a voicemail is not going to cut it. Third, what are the consequences of termination? I try and review this with my clients whenever we look at their employment agreement, but it's really important to understand the exit strategy set forth in your agreement. For example, once you give notice, what happens? Do you keep working during the notice period? Are you going to continue to be paid in the same manner? Does the time at which you give notice of termination impact your ability to receive some type of bonus or other payment? If any type of payment is tied to when you give notice, you're going to want to time that very carefully. So even if you're tempted to leave, make sure you're checking your contract and doing things right. Second, when you give notice, are you triggering a provision, such as a non-compete provision? Sometimes when you terminate, regardless of the reason, you're going to trigger a non-compete, but sometimes it depends. Often if you're terminating with cause, meaning the employer did something wrong, the non-compete might go away. If you're terminating without cause, then almost 100% of the time you're going to have a non-compete. So what does your non-compete say? Are you prepared to comply with it? Are you looking at jobs that would put you in compliance with that non-compete? This is really important. If you haven't taken a look and you're giving notice and you're leaving and you're going to find yourself in breach of that non-compete, you've just made a whole series of errors. So you want to be very careful. A lot of doctors still think that non-competes are not enforceable anymore. That is not the case. Depending on the state you're in, most states are still enforcing non-competes. Although there was a proposal by the FTC, it is not in place at the moment. That means state law controls your non-compete at this time. Make sure you know what that non-compete is and whether you're triggering it when you give notice of termination. What about other provisions of your contract that might be triggered? For example, malpractice insurance. When you leave, is there coverage required? If you have an occurrence policy, then you don't need to worry. But if you have a claims-made policy, a tail needs to be acquired. Whose responsibility is that? Well, if you're the one that gave notice, it might be yours, right? So you need to look at that provision and find out, if I give notice of termination, do I always have to buy a tail? Do I never have to buy a tail? Does it matter if I gave notice of termination with cause or without cause? What are the consequences? And it's a good idea to be prepared if you're the one paying for it, to know exactly how you're going to pay for it. Nothing worse than you give notice, you're ready to leave, and you suddenly have to come up with a very large tail payment that you can't afford. So planning is essential. What else is triggered when you go to leave? Are there repayment obligations? For example, a bonus or some other type of stipend that you have to repay when you go to leave? Again, these are often triggered depending on the reason that you're leaving. So whether it's with cause or without cause might really make a difference. The other thing that makes a difference is timing. A lot of these amounts are forgiven over a period of time. So if you're thinking of leaving before that time is expired, you might find that you owe these amounts back. Make sure you've planned ahead. If you're going to leave and you do not have the amounts that you're going to owe, the employer most likely has a right to take it out of final amounts that they may owe you and or come after you, particularly if you've signed a promissory note giving them the right to do that. So there's lots of planning needed when it comes to repayment obligation if you're going to be leaving. This is especially true if you have signed a separate recruitment agreement with a hospital or other employer. You need to make sure you're looking at that very clearly before you decide to leave. What other provisions might be impacted when you go to leave? Your contract might not be the same as everyone else, so you really need to scour it and take a look at what it says before you make any decisions. Remember, if you're talking with a new employer, you want to think about timing. You want to make sure that you're familiar with having to buy a tail. Maybe this leads to negotiation of some type of bonus. You want to know that you're not talking with an employer that's going to lead to a violation of your non-compete, because guess what? The new employer doesn't want to hire you if hiring you would cause a violation of your non-compete, because you're putting them at risk of getting sued as well. And most contracts will have you making a representation that signing the new contract does not violate your existing contract. So you really need to make sure that you're protecting yourself and, I guess, the new employer as well from being sued. So when you decide to give that notice, you're going to prepare a letter to your employer. You're going to make sure it complies with the notice provision that requires typically written notice delivered in a particular way. And you're going to indicate to the employer what your last day will be. If this is a notice of termination without cause, it's going to be 60 days, 90 days, etc. You're going to indicate what the last day will be. And of course, make it very clear that you're going to continue to work as normal during that period. If this is a termination for cause, you're going to indicate specifically what the reason is that you're terminating for and provide them with that opportunity to cure if it's required under your agreement. You'll again let them know that if it's not cured, your last day will be whatever that last day is. Again, make sure this is delivered absolutely as required by the contract so that everything is done perfectly and you are not accused of leaving without having followed the requirements of your contract. It's also important not to get tricked up by certain provisions that may not allow you to leave your contract for a certain period of time. So sometimes you might have agreed to stay for 2 or 3 years. And yes, you can give notice of termination without cause, but maybe it's only after those 2 years have ended. If you give notice before those 2 years have ended, you're the one that's in breach of your contract, and your employer can come after you for that breach. So you want to be very careful about that. Another common mistake when giving notice is not understanding a notice of non-renewal provision. A contract may have many different ways to terminate. It could be a notice that you don't want a contract to renew, a notice that you want to terminate without cause, and other reasons, right? If your contract only has a notice of termination by non-renewal, you need to read it very carefully. Sometimes you have that opportunity only once a year. So for example, if your contract says you must give 90 days notice before the contract renews, and you've missed that date by 5 days, 10 days, 30 days, you've got to wait now for an entire year cycle before you can give that notice again, which means you're locked in. If you leave before you give that proper notice of non-renewal, you're the one that's in breach of your contract. So be very careful. Make sure you understand this before you sign your contract. I like to try and get those removed when possible. There should always be a without cause opportunity to terminate as well in a well-written contract. So be very careful. Again, if you're giving notice of termination without cause, you still need to give notice in the proper manner, right? So make sure you're looking at that notice provision. There may be any number of other provisions that impact the right to terminate and your obligation. Make sure you're reviewing it carefully. I always suggest consulting with counsel. If you're on some type of visa or other immigration program, be very careful before you give notice of termination. Consult your immigration lawyer if you're not certain. And again, just another reminder, if you're talking with a new employer, one of the things you don't want to do is share a copy of your current contract with that new employer. Although I like to remind my clients of this, that itself may be a breach of your contract. So be very careful. One of the last pieces of advice I want to give you is that a good exit strategy comes from having a good contract when you first sign it. So take the time to review a contract before you execute it, review it regularly so you're familiar with it, and try and negotiate your exit strategy before you sign your contract. In the worst case scenario, if there are things in your contract that you don't love, whether it's a tail obligation, a repayment obligation, etc., at least know what your contract says. The worst outcome is being surprised and misunderstanding what you've signed, which can lead to a very bad outcome. If you have any questions about your contract, whether you're signing a new one or you want to terminate the one you're in, please feel free to reach out. You can always email me or give me a call. This is Ericka Adler from the Health Law Hotspot. We'll see you next time.
The Retzel Health Law Hotspot is made available by the firm and its attorneys for educational purposes and to provide general information, not to provide specific legal advice. Use of the Retzel Health Law Hotspot does not create an attorney-client relationship between you and the firm or any of its attorneys. The Retzel Health Law Hotspot should not be used as a substitute for competent legal advice, and you should contact an attorney in your state about any legal needs or questions you may have.